The news that we got today is really a victory for the people of Orange County, who overwhelmingly support the retention of Valley View as a county-owned facility, are highly skeptical of the arguments against its retention, and have voted for legislators who have campaigned on platforms supporting Valley View. Curly Dillard and Newberg campaigned in support of Valley View, and then the only Democrat voted the opposite direction a few months back. The people of our county are strongly committed to protecting the elderly who live in Valley View, the veterans who live in Valley View, and their lives and plight are of great moral concern to us. This is one case where the legal process must mirror those moral virtues and concerns. And frankly, the discussion about Valley View, which has been punctuated by much misinformation, has been anything but straight and honest. And those who have engaged in the deceptions, not only the prior administration, but now the current administration, should really be ashamed of themselves. That's the background. We're here today because the rule of law did prevail. Many of you who've been involved in this thought it would. I thought it would. We applaud Judge Slobod for the expedition with which she handled this matter, because obviously the court must understand, and I'm sure she did, this was a matter of great public importance. And she did not need, frankly, to take months and months in rendering this decision, nor did she. Now, the decision should in no way be obfuscated, and it of course concerns me that it's a legal decision, and like anything else, people think it's subject to a lot of interpretations. This decision is not subject to many interpretations. This decision is extremely clear. So let me, in a few words, tell you what it says. It says that when a county transfers, alienates, sells, rents long-term, like for 99 years, a piece of real estate, whether it does that to a local development corporation, which is not the county, it's a separate agency, or does it to someone who is in fact a private entity entirely, it must do so consistent with County Law Section 215. The fact that local development corporations exist in New York and exist by virtue of another statute does not change the application of County Law 215, which is what we argued and what seemed to us fairly clear. And I think, as the judge indicates, it's fairly clear to her. Now, once Section 215 applies, a supermajority vote, here 14 of the 21 legislators, are required before an action, whether it be by local law or resolution, is effective. Here, 14 votes did not exist. I don't believe 14 votes do exist. And therefore, critically, the transfer of this property is nullified. The resolution which was passed is a legal nullity, because it's as if you needed a majority vote and you had 8 of 17. It doesn't pass. If everybody's there, you needed 9. So it didn't pass, and that's the end of it. Now, is that the end of the issue? It's not necessarily the end of the issue, but it's the end of that process, and the LDC thereby created is a nullity. Now, the judge did not reach the second issue. At least didn't reach it in the sense of deciding it squarely, because correctly she felt it was not necessary, having decided the first issue and thereby nullified the resolution, she need not reach the second issue. That may be arguable legally, but the second issue is addressed in this way in the decision. The second issue is whether, when you do away with or significantly alter the operation of a unit of Orange County government, whether our county charter requires that you act by a local law. That has nothing to do with the supermajority. Hello? Come right in. It has nothing to do with the supermajority. A local law can be passed by a majority. The attribute of a local law, though, is that if you operate by local law, you have a permissive referendum available to the population. So you can pass a local law by a simple majority. But if you act by local law, it allows the public to cast a vote if enough signatures are gathered. The judge didn't reach that issue because she didn't need to nullify the resolution. The resolution was nullified because it did not have 14 votes. So the bottom line for today is that the public in our county have now I believe with regard to Valley View, the situation that the public in Orange County wanted, which is Valley View is continuing in county hands. Now there can be legal maneuvering here, lest anyone not imagine that. And let me tell you the legal maneuvering that's possible. The county could appeal. Anybody can appeal anything. Judge Slobod's decision seems based clearly, correctly on logic. And let me explain a little bit further the legal logic, if you will. 1411, that section which the legislature passed enabling the creation of local development corporations, was enacted approximately 60 years after the enactment of County Law, Section 215. If the legislature did not want the local development corporation in taking or gaining property, did not want the county giving it property to have a 2/3 majority, then the law creating that LDC, Section 1411, would likely have had a provision saying, if and when you transfer property to an LDC, you can do it by majority vote. It doesn't have any such provision. Therefore, we argued that the way a county transfers property and must transfer property by 2/3 still applies. Why? Because in creating the LDCs and dealing with a lot of other provisions concerning transfer of property, which were changed, this 2/3 majority provision was not changed. And the judge accepted that argument, and I think it's really the only logical construction. If the county appeals, they may argue that they have an automatic stay. Now, this is where things get interesting. Where a municipality takes an appeal, they can get an automatic stay. If they take the position they have an automatic stay, we, if we felt it necessary, would go to the appellate division and ask the appellate division to erase the automatic stay and deem null and void the provision and ineffectual the provision, that is the resolution, until and unless the second department reversed the decision. I am confident we would get that relief under these facts. I'm hoping, perhaps the Russian expression comes into play here, hope against hope, nadezhda protiv nadezhdu, that's the Russian for it. I'm hoping against hope. That's a saying that Osip Mandelstam, a famous Russian poet, came up with during the period when many Russian poets were being exiled to Siberia in the 1920s and 30s. In any event, I'm hoping that the county will not appeal. And I'll tell you the reason why, and we come back full circle. I was in Valley View, Pat was there, Jerry was there, Maddie was there, Dot was there, and others were there recently. When it was last Monday night, I think we spoke over there. Mike Anagostakis was there, speaking as well. And the feeling I had there was one of tremendous sadness, and I said it that night, a really shamefulness. Mike has put it very well in explaining that this is the only county department which has in fact been asked to and has radically and significantly achieved savings. Whoever wants to come in, please come in. And hello. And those savings have not been requested of other county departments. Valley View has probably almost by a third cut down its operating expenses since the days of Eddie Diana. And the people in Valley View, the people we spoke about earlier, need the security, need the feeling that they have a home again, and that their home is not always up for grabs and is not always on the chopping block. So again, morally, having suffered this defeat, I think the county executive and the legislators should work together. They have new information, they have additional federal monies which they didn't have or didn't know about several months ago, and they have to have a resolve to make the facility work. And I'm hoping that enough of the legislators will see that and not appeal. I'm not concerned about the legal merits of an appeal. I feel very comfortable about that. But I am concerned that the message an appeal sends is the continued tumult in the lives of the people and the staff. The staff have gone through an awful lot. I mean, think if your job was in jeopardy every day for 3 years and you never knew whether you had a job, and you know, talented people are going to get other offers and say, okay, you know, I better make a decision for my own best interest. And putting people in that position is terrible. So I'm hoping that for those reasons, the county executive, and I'm asking the county executive for those reasons, not to file an appeal,